Hello, so today we're going to learn about drafting charges, which is one of the most important topics in the criminal litigation course. Now, what is a charge? A charge really is the sheet which is drafted containing the information for which an accused person or a defendant is being tried. So at the start of the criminal trial, when the person is arraigned before the courts, the charge is read to the person, and then the person is called upon to enter his plea to the charge. Entering the plea meaning to enter a plea, maybe of guilty or not guilty, or whatever else he has to say. So how are charges drafted and why are charges drafted? Now, charges are drafted very importantly because the accused person has a constitutional right to be informed of the offense or offenses for which he is being tried, so that he could prepare an adequate defense for himself. Because if he is not properly informed, then that would lead to a mistrial, as he would not be able to prepare a defense for himself. Now, how do we draft charges? Now, in the different courts, you would find that we have different formats that we adopt for drafting charges. Now, in practice, some peculiarities which are emphasized in the law school criminal litigation curriculum would not apply, but we're going to be learning it per the law school curriculum. So we would look at the draft in the magistrate courts in the north and in the FCT, and then we would look at the draft in the magistrate court in the south and in Lagos State, and then we would look at the draft in the High Court in the South, in the High Court of Lagos State, in the High Court of the FCT, the High Court of the North, and in the Federal High Courts. So you're going to see certain differences and nuances in how the format differs across the different courts. But the first court we shall begin with is the Magistrate Court in the north. But before we take that on, just taking a step back to talk about how criminal proceedings are instituted in the different courts. Now, when we learn about institution of criminal proceedings in the different courts, you recall that in the magistrate court in the north, the proceedings are instituted by lay a first information report before a magistrate, following which the magistrate would draft a charge against the accused person. That's how proceedings are instituted in the magistrate court in the north. The police prepare a first information report, which is laid before a magistrate, and then the magistrate drafts the charge against the accused person. Of course, the first information report is a report prepared by the police which would contain the findings they have made from the investigation. Now, in the South and in Lagos State, it's by charge. The charge is drafted typically by a police officer, and the accused person is tried upon the charge. Now, in the Federal High Courts, the High Court by filing a charge, and then finally, in the High Court of Lagos State, in the High Courts in the South, and in the High Court of the FCT, the mode of instituting proceedings is by information filed by the Attorney General of the Federation or by any officer in his department. And of course, Attorney General of the states when it has to do with the respective states. So those are the different modes by which charges or trials, criminal proceedings are instituted. So in the next video on charges, we would now begin to discuss how charges are drafted, particularly in the magistrate courts in the north. So I'll see you then. Bye for now.